Hello?
Hi. My camera is not working.
Yeah, it sounds like you're just stabbing a computer key.
Very much, yeah. But I was also trying to mute Cool Math Games because I was playing Fruit Ninja.
I have no clue what that is, but sure.
Now I have to show you.
Anyways, I have checked the settings this time.
So it's gonna record the audio?
Yeah, I've tested the settings. I've tested a recording to make sure it would actually record.
Yeah.
And it does. Hello and welcome to the second attempt at the first episode of Lady Justice. We did record a previous episode, however, technology hates me, and I totally did not record the entire thing without audio. This podcast is an attempt by some prospective law students to take a look at some of the primary units that would be studied within a law degree in order to get an idea before making our applications. Just a disclaimer, we are not law students, we are not law academics, we have no formal legal training at all, so take what we say with a grain of salt. I am your host, Rowan, and this is my co-host, Emer. Say hello, Emer.
Hi.
This episode, we are looking at contract law. What's your thoughts on contract law? Not the biggest fan?
Not that. It's just not something that interests me.
Yes. I have
a attention span for it.
Yeah. What I like about contract law is that it is the foundation for so many other kinds of law. You'll see what I mean when I'm describing this later on. What is your current understanding of contract law?
Pretty much, you sign a contract and then you have to do the things on the contract, and then if you don't do that, they'll sue you for breach of contract. And then there's extra bits.
Care to describe any of these extra bits? Do you know of any of them? Or just that they're...
Well, you can get out of contracts, but it has to be in specific ways. I know more about this than I did the last one, to be fair, though. So
yeah, that's fair. This is that is actually a pretty good basic understanding of it. So the basis of contract law is that, and this is different in British law than it would be in American law. In contract law, in British law, there is a requirement for consideration. So both parties need to agree to something, and there must be an exchange, meaning that both parties must get something out of it. So it can't just be a contract. If you are agreeing to give someone something and they have no requirements within that contract, that is not a contract under British law. Both sides need to be getting something out of it. Then other main points would be, for example, in a contract, what you say is what matters, not what you mean. So it doesn't matter if both sides understood that when you said, not an actual example, say you in the contract described something as red and it's actually pink. You have a right to all the red flowers within this flower shop. And you meant anything that has red pigment, so it could mean pink or whatever. That's not what you said. So even if both parties understood pink flowers to be included in that, it's not, and that cannot be upheld by a judge. If that makes sense. Does that make sense?
Yeah.
Great. In addition to this, what is your understanding of the role of a judge within contract law?
If there's a disagreement over what the contract means, or someone breaks it, then they step in and be like, yo, you can't be doing that.
Yes. So one quite common misconception about it is that the judge is somehow involved in the making of the contract, which is not the case. That is done between the solicitors. The actual contract, the only time a judge would be involved within a contract is like you said, where someone has broken it and where they're trying to decide whether someone has in fact broken it. You also mentioned earlier that there are certain ways that a contract can be broken legally. Any clue what any of these? There are three main ones. Any clue what any of these three main ways to make a contract invalid would be?
Like if you quit your job or get fired. Because then you've signed a contract and then you technically cannot break it.
Okay, that's actually quite far from it. Because say you've signed a non-disclosure agreement with your company.
Yeah.
And you get fired. That non-disclosure agreement.
You can't break that.
It's still valid. It would depend on the contract, but that's not you breaking the contract. It'll be written into the contract. This is valid until whatever. I'm talking about specifically. It's not written into the contract that it'll break at this point. It's something that makes the contract invalid. So, what would you think if, for example, little hint, someone's holding a gun to the person's head when they sign it? What would that be called?
Oh, that breaks it because then it's not you're not actually consenting to it.
Yes. So that would be
consent under threat is not consent.
Yeah. So if a contract signed under duress, then it's an invalid contract. The other two would be mistake or misrepresentation. So, do you have any idea what mistake or misrepresentation would be?
Mistake if they put something in that's just not right. It's factually incorrect.
Can you give an example of what you mean by that?
Say I say you can have 4 of my books, but I don't mean but I don't have 4 books. I have 2 books. Then that's a mistake because I don't have enough books to give you 4 books.
Yeah, I'd say that's pretty fair. Mostly mistake refers to when you agree to something without knowing the key facts. So in that example, you're agreeing to give 4 books without knowing without the other person knowing that you have only 2 books. There is a mistake in that, but it's not quite because it's physically impossible. It's more within the lines of that would probably fall within. I think that would probably fall within misrepresentation. Actually, mistake is when something has been left out and someone is signing something without it's you can't consent to something if you don't have all the information.
Yeah.
I'm stealing your likening contracts to consent.
I just it's basically the same thing.
It is. It's a legal written version of consent.
Yeah, well, consent is just a verbal contract.
Yeah. Yeah, it's just a written version of that. So another part of mistake is that there is a mutual reliance. So there needs to be both sides need to be aware of the same thing, but they both need to be agreeing to the same thing, but if one of them doesn't know something because they haven't bothered to ask, that does not qualify as mistake. It has to be if something is common, they should have known but they didn't, that doesn't count. It has to be there was a good reason that they didn't know. Oftentimes, the mistake comes in where something has been messed up not by the parties but by the solicitors.
Yeah.
Then there is the misrepresentation. And what would be your guesses as to what misrepresentation would include?
So would it be kind of it's not what someone actually thinks? But obviously you read a contract by what you were saying,
mm-hmm.
But if someone takes it in to mean a different thing, then that doesn't make any sense. Never mind.
No, I get what you're saying. It's an induced mistake. So it's where one party has represented something in a way that it isn't actually. So the legal definition of this would be unambiguous false statement of existing fact or law which is addressed to the party who is misled and induced to enter into a contract. So it's where you sign the contract under the understanding that it is something that it isn't. Where the other party has purposefully convinced you that it isn't, that it is something different to what it is. The difference between... Do you want to guess what the difference between... what the main differences between mistake and misrepresentation are?
Misrepresentation's more like someone's trying to like get something in from the contract that's not technically there because they're not telling you all the facts, or they're like writing it in a way that means that it's not like right, or a mistake's usually more like kind of accidental.
Yeah, so you've got both the points there. It's about the placement of the fault and it's about the purpose of it. So in mistake, the fault is either on the solicitors or on both sides or neither side. Whereas in misrepresentation, it's specifically on the side of one person who has is been purposeful in trying to deceive, and it's an immoral use of it. Mistake is you've done something by accident. Misrepresentation is one party has done this on purpose to take advantage of the other side. Within English law, it is far more accepting of one of the two than it is of the other. Do you want to guess which one it is that it accepts more?
Mistake, because it's an accident.
Nope, misrepresentation. Because there's actually a logic to it. It's because in a mistake, both parties are to blame. So we're gonna let them deal with the consequences of it because both of them are at fault. We're not gonna break the contract.
Figure it out yourself.
Yeah. Whereas where it's misrepresentation, one side has or both sides, if both sides have done it, has inherently done something wrong, and so you're trying to protect the one who has been wronged. So the judge would be more likely to break the contract in favor of the one who has been wronged. There is, however, a very important point in this, which is like philosophical. It's not like a dead point. It's if you suspected the lie, is it still, and you didn't question it, like you were lied to, you suspected it was a lie, you didn't know for sure, but you thought it was a lie, and you still entered into the contract, is that misrepresentation? What's your thoughts on that?
Well, like, it is, because you're lying, but then also if it's your fault, so like,
yeah,
like, obviously it's still misrepresentation, but it's just on whether you think misrepresentation becomes less valid if the person had some kind of suspicions before they signed it.
Yeah, that's pretty much, in very simple terms, what the Hayward and Zurich insurance case, like, and all the people who look at this, it's very much that's the conclusion of, well, they did still do something wrong, but the other party could have done something about it and didn't. So, yeah. Then there is also within these cases, the there is also, like, you can, these are the three reasons that you might be able to break them. The main one, the main example for like breaking of mistake that's used would be Smith and Hugh, which this is something that's very interesting within contract law. From the lectures I've been to on it, the examples they use are so often so old. Do you want to guess when around about the Smith and Hughes case was from?
I'm going to go with 1963.
1871.
That's not what I thought meant by so old. Surely law is different now.
Well, no, well, especially within contract law, the bases of contract don't change.
No.
If you're looking at things like criminal law, like the criminal laws get changed by government regularly. Like, in 1871, a lot of the things that are legal nowadays wouldn't have been, or that are illegal nowadays wouldn't have been. Back then it's still legal to, like, beat your wife. So, you know, yeah. Then within, like, the actual, like creation of the contract, so we looked at what, like, validates breaking a contract. Within a contract, like, when you're making the contract, what would you imagine are the main things that you need to have in order to form a contract?
You need, like, something that you actually need to have an agreement on. You can't, there's no point in making contracts willy-nilly. Then there's like, actually both of you want to sign it, because if one of you don't, then, like, shouldn't be doing that.
Yeah.
What's this one? You need to, like, know what's going on. You need to know what everything, all the, like, important points and stuff.
Yeah. So you got most of it there. So the first one was offer. So it needs to be a valid thing that someone's giving to someone, like someone is making a suggestion to someone else that is valid it's a valid offer. Then the other party needs to accept that offer. And then there needs to be a certainty, so both sides need to know what they're agreeing to. And then there needs to be an intention to create the relations, and then consideration, which is what I mentioned earlier. So you got most of that, like, not in the official terms, but you got, like, what most of that was there.
Yeah.
And consideration, again, is something that is unique to the British system. It's not something that, like, exists in all legal systems. I don't think the US requires it. But yeah, so you need to have do you know what an offer would be? What offer is? Like, how would you define it?
Like, what you're exchanging or, like, making the contract about. Like,
Yeah,
if I'm selling you something, then the offer is the fact that I'm selling you something. Or if I'm getting a job, it's the fact that I'm getting a job.
Yeah. So it's a definitive statement that a party is willing to be bound by. So, yeah, that is, yeah. There is a difference. There is an invitation to treat, which is different from an offer, but can commonly be confused. What would you say what would you guess the difference is between an offer and an invitation to treat?
An invitation to treat's a bit less, like, it's a bit more wishy-washy. So it's a bit less, like, clear what exactly it is, what exactly it's for.
Yeah, it's that's right. It's a statement that's indicating a maker's willingness to receive an offer. It is not them themselves saying, we are offering you this. It's, we're open to making a contract. What would you be willing to suggest? What would you think a common example of an invitation to treat would be?
Like, if someone gives you kind of like an offer on a house, it's kind of like, we'll discuss what the money, like, how much we're expecting and stuff. Like, it's not the actual offer. It's not like what you go into signing the deeds for your house for, but it's kind of like what you would suggest, and then you kind of discuss it, and then you have your final like the final amount you pay, which would be your offer in this situation.
It's like when you're expressing an interest in, like, buying the house.
Yeah, and you're like,
yeah,
this is how much I'd be willing to give, and they're like, well, no, this is how much we want, and you would sign a contract on how much you're actually going to spend.
So within that example, there is an invitation to treat, but it's not the, like, potential buyer, like, giving, like, an offer. It's the seller putting, like, advertising their house as being for sale. So the invitation to treat is, like, advertisements is a very common, like, invitation to treat. When the seller puts the house on the market, they are saying they are open to receiving offers, which then the potential buyer will give. So you raise an interesting point there. Just because an offer is not definite, so it's not the final one that goes into contract, it is still an offer. They'll negotiate it and they'll change it out, but they are still making an offer. one of the big cases that kind of gives us an idea of what of like the difference between offer and invitation to treat would be, and I mentioned this the other day, the Carbolic Smoke Ball case, which is a very well-known case. What is your understanding? Sure. Have you ever heard of this case?
I've heard you mention it once. Well, twice now.
What did I mention it was about?
It would be great if I could remember that.
I absolutely adore this case. It is about, I just find it so funny. It's about influenza.
Yay.
Specifically, it's about a treatment for influenza. Do you want to guess, based on that, like I said, a lot of these cases are pretty old. Do you want to guess what time period this case is from?
My guess, I want to say like 1918, because like Spanish flu. But then I feel like it's probably earlier.
Yeah, it's 1893.
When?
1893.
Oh, I was closer that time.
You were closer that time. So within the Carbolic Smoke Ball case, if I can find my notes on it, where was it? Give me a sec. There we go. So the official name of the case was the Carlill and Carbolic Smoke Ball Co. 1893. And essentially, the main fact in this case was the defendant was the Carbolic Smoke Ball Company, and they placed an advertisement in a newspaper for their product, offering that any person who purchased and used the product but still managed to contract influenza despite using it how they were supposed to and how they were instructed to use it would be entitled to a reward of £100, which nowadays you've got a life-threatening condition which will probably kill you. £100 might not seem like much, but in 1893 it was a lot.
Quite a lot of money.
Yeah. So people were actually interested in trying this because either it works and you don't get influenza, or it doesn't work and you get a very large sum of money. The advert further stated that the company had the company was committed to offering this by having placed £1,000 in a bank account to act as this reward if claimants claim it. I mean, looking at that personally, I would think, oh, so you don't have confidence that your thing's going to work and you've got money set aside to pay when people get it.
But that's only 10 people's worth.
Yeah. So maybe they were like, yeah, it probably will work for most people, and there's maybe 1 in 100 who don't. Maybe this weren't expecting to sell very many. The claimant, Mrs. Carlill, purchased some smoke balls and used them exactly as she was supposed to. And do you want to guess what happened?
She got the flu.
She got influenza. So she attempted to claim her £100 reward from the defendant. And obviously this went to trial, so do you want to guess what happened?
They didn't have enough money.
No, they just didn't want to pay her. Yay, capitalism. The defendant, so the smoke ball company, contended that they could not be bound by the advert as it was an invitation to treat rather than an actual offer, because invitations to treat, as we were discussing before, are not an actual offer, it's not an actual contract. Because obviously if you've got a contract and you sit it down, when you think contract, you think it's a written set of agreements that both parties sign. But that's not necessarily always the case. Can you think of what other types of contract there could be which would still be legally valid?
Sorry, I zoned out with it.
So, when you have a contract, most people would think of it as being a written set of agreements that both parties sign. But
yeah,
you have to have a contract requires there to be an offer, an acceptance, and an offer, acceptance, certainty, intention to create legal relations and consideration, it doesn't require there to be anything. None of those things require it to be written. Written contracts just offer that like solid proof. It doesn't necessarily. So you can have contracts such as, if this was deemed a solid contract, where it's simply they have made an offer, and in this situation, what would you class as the step where the buyer is like accept? What would you class the line of acceptance as being?
Like when they buy the product?
Yeah, exactly. Yeah. And so if that had have been an offer, that they have said, buy our product. If it doesn't work, we give you £100. That was the offer they made. And they bought the product, they used it as instructed. That's acceptance. The problem is that they were like, yeah, no, it wasn't. We weren't actually saying that. That was just us saying things. It was an offer. It was an offer. It wasn't an offer. It was we were just words. We weren't actually making a proper offer. So, therefore, it was an invitation to treat rather than an actual offer on the grounds of that advert. It was, in their words, mere puff and lacking true intent. That an offer could not be made to the world. The claimant had not technically provided acceptance. The wording of the advert was insufficiently precise, and that there was no consideration as necessary for the creation of a binding contract in law. So what would you say the main issue is here?
Whether or not it's a binding contract and whether your woman can get her money. Yeah,
so the question, so within that, like what the judge is having to decide in order to decide whether or not it's a binding contract is, was this actually an offer or was it just an invitation to treat? What do you think was the decision made from this?
That it was just an invitation to treat?
Yeah, actually, funnily enough, no. The Court of Appeal found for the claimant, determining that the advert amounted to an offer for a unilateral contract by the defendant. So essentially what they were saying was that it was an offer, it was an actual offer, it wasn't just an invitation to treat, and in fact, a offer could be made to the world, as the claimants, as the defendants were saying, you couldn't do. And as we mentioned earlier, they deemed that Mrs. Carlill had offered acceptance in buying the product. The advert's own claim to sincerity negated the company's assertion of lacking intent. So the company had said, we're not actually, in court, the company had been like, well, we didn't ever actually intend to pay them, but in the advert, do you remember what they said about what they were doing with the money?
They put £1,000 in a bank account.
Yeah, so within their own, they had within their own advertisement said, no, this is our proof that we are actually going to do this. And therefore, yeah, no, you did intend to do it. Whether or not you actually intended to do it, you had sufficient proof that you intended to do it, so, yeah. And so it was deemed an offer could be made to the world, as long as the wording was reasonably clear to imply terms rather than it just needing to be entirely clear. It didn't have to be absolutely perfect. It just needed to be reasonably clear that a reasonable person would consider it to be true. So yeah, the contract. That is why this case is so like well known and so important in the study of contract law, because it makes that very clear that like the average person might assume, oh no, that isn't. Of course, they found in favor of the thing because that in favor of the company. But no, it is very much if you have made it clear that you intend to follow through with something, then follow through with it.
Yeah.
This particular case is this is like I was mentioning before that this is a very old case. This is from 1893, but
Yeah.
even older cases are used a lot of the time within contract law for its very basis, because obviously we all know within English law, it's an unwritten constitution. All of our laws are made based on rulings within cases. Like, you have the actual law that's written by the government, and then how it's practiced is based on the rulings by judges. Hence, case law. So even cases as old as like cows and sheep and bartering and all that are still relevant within contract law because it sets the foundations and it doesn't really change that much. The terms you use, how detailed you're being, that changes, but the actual idea of one person makes a suggestion, the other person agrees to it, they both know what they're getting out of it, they both get something out of it. That is a very that basis is very simple, and then it just gets more complicated when you're adding in all the small terms and legalese and all that. So yeah, essentially this is the way that the lecture that I was listening to talk about this went over it. Was the case is essentially a cover case for not making open offers. It's a bad idea to say to anyone, "We will do this if you do this." Because then say you were only it doesn't matter that you were only expecting, say, 10 people to participate. 1,000 could do it, and then you're still bound by it. So yeah, that's the fun part of contract law, in my opinion. Do you still dislike it? Do you still find it really boring?
Not like really boring, but still kind of like, yeah. Like, I don't think I could do it. I think I would get very bored very quickly.
You could do the contract law module, but you couldn't work in contract law.
Yeah, I could.
Yeah.
Well, how long would the module be? So long as it's not too long. If it was I feel like I could do it for a month max, and then I'd be kind of way too bored with it, and I'd just be like, I'm dropping out of school.
Well, it's usually a semester.
Yay!
But you'd be doing multiple different modules. You'd be doing 2 or 3 modules at the same time. You can scrape your way through that.
Yeah.
So that brings us to the end of the notes on contract law. Do you have any points you want to bring into this? Any questions about it?
No.
Okay. Well, thank you to anyone who has put up with us discussing this. We didn't go as off topic on politics this time.
There wasn't that much to go off topic on politics on.
No. I'll have to choose a more controversial one next time. What do you want to do for the next one?
I don't know. I could have gone on off topic and talked about the precedents stuff within politics, within law in general, because we learned about that a few months ago. That was the start of this year. Because the UK's not got a written constitution and stuff. But I didn't. So
I'm proud of you. Thank you to anyone who has listened to us ramble on. That is the end of this episode, and yes, thank you for listening.